be present with us in a virtual setup, and we are deeply grateful for the same.
We would also like to welcome our keynote speaker, Professor Dr. Claudia Maria Hoffman, Professor and Chair of Public Law and European Social Law at the European University Viadrina, Frankfurt. Ma'am is also present with us virtually.
We also welcome a distinguished guest, Dr. Sandeep Sharma, who is the member of the Indian Council of Medical Research and Committee of Standard Treatment Workflows and consultant plastic cosmetic surgeon. As a token of our appreciation for his presence, I request Dr. Hitesh Bhatia, the Dean, School of Business and Law at Navrachana University, to please extend a warm welcome to Dr. Sandeep Sharma.
We would also like to welcome Dr. Medhavini Ayachan Ma'am, COO at the Zydus Hospital, Vadodara, and Dr. Yograj Singh Jala, the Head of Department, Medical Services at Zydus Hospital, Vadodara. Thank you for your gracious presence.
Along with the distinguished guests, we are also joined by Dr. Hitesh Bhatia, who is the Dean of the School of Business and Law at Navrachana University, and Dr. Sujata Patil, the Principal of Law at the School of Business and Law at Navrachana University.
We are also pleased to welcome all the deans, program chairs, faculty members, and students who have joined us from various disciplines across Navrachana.
We thank all the dignitaries for gracing us with their presence. With your due permission, we would like to start the inaugural session. Light represents brightness and prosperity. Just as sunlight removes darkness, blessings brings prosperity and happiness into our lives. To make this event a grand success, one invokes the blessings of Goddess Saraswati by lighting the lamp of knowledge and wisdom. For seeking the choicest blessings for the same, I hereby invite all the dignitaries to please come forward for the lighting of the lamp.
It is my pleasure to introduce the Principal of the Law Department, Dr. Sujata Patil Ma'am. Dr. Sujata Patil has completed her PhD in the area of intellectual property rights from the B.R. Ambedkar Law University, Tamil Nadu. Ma'am has worked in several reputed institutions in Bangalore for around 15 years before joining Navrachana University as a principal of the law program. Ma'am is also a recipient of several prestigious awards and has published research papers in reputed national as well as international journals. I hereby invite Ma'am to please deliver her introductory address.
Thank you, Anita. Very good morning to one and all who are present here. On behalf of law, I take this opportunity to extend a warm welcome to our distinguished guest of today's event. We have with us B.C. Patel, Honorable Justice, Professor Claudia Maria, and also we have with us Dr. Sandeep Sharma. And there were two more doctors who are going to join with us from Zydus Hospital who have been associated and collaborated for this conference. I mean Dr. Yograj and Dr. Medhavini. And also extend a warm welcome to all the resource persons who are going to chair today's technical session. Student and the Dean of School of Business and Law, Dr. Hitesh Bhatia, the Provost, due to some emergency, could not join, Professor Pratyush Shankar, all my faculty colleagues, and most importantly, all participants, welcome you for this today's event. When coming to the theme of the conference, if you look at the title of the conference, it seems to be a bit specific rather than generalized. And people may think that it is just connected to the law and healthcare. But this year, this is our seventh international this time because we are able to connect to the international university. We got a very huge response. Around 80 papers we received across the country. And out of 80 papers, 40 within our university and 40 from outside. And out of 40, the best part is that just 10 papers are from the law program. The rest, all 30 papers are from different programs of Navrachana University, from psychology, from journalism, humanities, science, technology. This is how wherein I can say that this title connected to the interdisciplinary in nature. And as we all know that, and in this present era, it is very much evident that medical science, there is a rapid advancement of medical science and technology. And due to this advancement, the healthcare sector is facing a lot of challenges in terms of legal and ethical issues, which ranges from, if we take an example, from the rights of the patient, role and responsibility of the doctor, data protection of data privacy, or it could be a medical negligence, or it could be an equitable access to the medicine and medical services. These are all the issues which are revolving around the healthcare, but it is not easy to understand. A standalone law is not enough to understand what exactly the challenges that the healthcare sector in the present era is facing. There are various other laws that are connected to the healthcare sector wherein it is going to regulate the system. And with that intent, we just connected to the various other laws that are falling within the purview of medical jurisprudence. The laws like constitutional law, the supreme law of the land. And here we received a paper and we just connected the interconnection between the constitutional law and healthcare, IPR and healthcare, labor law and healthcare, Consumer Protection Act and healthcare, environmental law and healthcare. This is how the various laws are going to connect. And this is a platform where today we are going to be able to understand how all these laws are interconnected to the healthcare sector and also balancing the interest of doctor and the patient. If I take one best example to connect the, right now I mentioned IPR. IPR is a vast area, and if you take a patent which gives the monopoly for whatever the type of an invention that you are going to come up. And in the field of healthcare and in the field of pharma industry, both are healthcare sector and the pharma industries are interconnected to each other. And the patent gives the monopoly to the pharma industry and also the new technologies that are coming up in the healthcare sector. Right. The technology is helping out and easing out the role and responsibility and the duty of the doctor, and also it helps the patient. But on the other way around, if the doctors are going to operate with the help of technology, a robotic, a mechanism, now people are coming in the big hospitals. If something goes wrong, whom should be held responsible? A doctor or a technology? Whether the present policy and the law are in place to mitigate these issues and the challenges, that is one big issue. And when I talk about pharma and the medical sectors are interconnected to each other, yes. The pharma industries is the one which is going to come out with a medicine. And as we all know, globally, India stands in the first position in coming out with the generic medicine and supplying to the international and the national market. But there are few companies, around 20 to 30% of the big pharma and MNC companies are coming out with the branded medicine. And they'll have the tie-up with the big corporate hospitals. And the year comes, doctors are going to prescribe the branded medicine. And the cost of the branded medicine is 10 times the double the generic version of the medicine. And the generic version of the medicine are supplied free of cost by the government to the poor and needy people and are only in the government hospitals, not by the big corporate hospitals. And this is how the strategy and the tie-up of this pharma and the healthcare sectors, somewhere it goes against the interest of the rights of the patient. And also, this strategy are misusing the dominant position by large-scale sectors in this market. It goes against the interest of the medium and small-scale pharma sectors, which are dependent on generic manufacturing. And here comes the application of the law. One hand, IP provides the monopoly. On the other hand, when it comes to the misuse of dominant position, here comes the role of competition law, which try to curb the misuse of dominant position. This is how we need to understand in the different angle the law related to healthcare. And even the constitutional law, we say that supreme law of the land and the fundamental rights guaranteed to all the citizens. Right to life includes right to die in a dignified way. And right to die, here comes the concept of euthanasia. I hope you all aware about that. If the patient is not able to survive, putting an end to the life of the patient rather than giving a pain to the patient. And here the call will be taken by the family members and the doctors. And when the doctors and family members are going to take a call, they should be more cautious when it comes to the ethically, morally, and the legally, because we are taking a call against the interest of the patient. So these are all the issues, just one or two examples I've just put forth. This is how today's conference and this platform will help us to understand a diverse way what are all the laws that are playing a significant role in regulating and balancing the interest of doctor and the patient. So I hope today this one-day conference definitely help us in understand in the diverse area. And also this conference should not only share or gaining the knowledge, we must come out with some strong suggestions and the recommendations which will help to the policy maker, and we are able to fulfill the gap in the existing law and policy, and also we are able to mitigate the ambiguity that is existing in the existing law and policy. With this, I wish all the best to all the participants, and thanks to the organizing committee giving me an opportunity to share a few words.
Thank you, Sujata ma'am. Dr. Medhabini Ayachit ma'am, the COO at Zydus Hospital, and Dr. Yograj Singh Jhala has also joined us. We welcome you warmly, ma'am and sir. I am privileged to be announcing our distinguished chief guest for the event, Honorable Justice B.C. Patel, sir. His Lordship has obtained a degree in law and also a master's degree in economics and politics from the Gujarat University in 1967. His Lordship later enrolled as an advocate and started his practice in the City Civil Court, Ahmedabad from 1968 onwards. He later shifted his venue of practice to the Gujarat High Court from 1970 onwards and joined the chambers of a well-known criminal advocate, late Mr. H.K. Thakur. His Lordship practiced independently as an advocate in the High Court of Gujarat from 1981, specializing in civil, constitutional, and criminal law matters. Sir has represented the Gujarat Electrical Board for over 10 years in various courts. Sir also has a keen interest in education and has also worked as a professor of law in various colleges for about 15 years. Sir was elevated to the bench of the Gujarat High Court as a permanent judge in 1990. As the judge of the Gujarat High Court, his lordship delivered landmark judgments, particularly on town planning and building activities in urban areas. The celebrated judgments delivered by his lordship paved the way for removal of encroachments from public places and installation of safety devices in high-rise buildings. His Lordship has also held the position of the Acting Chief Justice of the Gujarat High Court and was elevated as the Chief Justice of the High Court of Jammu and Kashmir, later transferred as the Chief Justice of the Delhi High Court. His Lordship retired as the Chief Justice of the Delhi High Court on 7th of August 2005. We are honored and privileged to have His Lordship here with us virtually today. I hereby invite His Lordship to please share a few words of wisdom with us.
Thank you very much for providing an opportunity. Your School of Business and Law, by holding the 7th conference on the International Conference on Law, Ethics and Policy in Healthcare, has provided an opportunity to think for better health, to live a good life. Dr. Hoffman, Ms. Shipra Shayal, Civil Judge, and Sandeep Sharma, as well as dignitaries of the university in the hall. I wanted to be present there in person. However, on account of an injury on the foot, I missed the opportunity to be with you all. People throughout the world are facing serious problems pertaining to health, including communicable diseases like HIV and tuberculosis, non-communicable disease such as heart disease and cancer, mental health issues like anxiety and depression, and environmental threats like climate change and pollution. Other significant challenges including malnutrition, health inequalities, substance abuses, and the growing problem of antimicrobial resistance. Pollution and adulteration in food are the worst enemies. The Prevention of Food Adulteration Act has been repealed by Safety and Standards Act. But you know the proverb, old wine in a new bottle. The same continues. I would like to give some examples whenever necessity arises. It is said in India that milk produced is less than the consumption of milk. Many are agreeable, many are not agreeable. Nonetheless, there are reports that during certain occasions like Diwali days, people are found using chemicals to prepare milk and sweets. In various food substances, poisonous articles are added like methanol yellow, and people face serious consequences because of such food. Of course, nowadays, the companies are there to supply material in a package. So the danger has been reduced, but it has not been at all eradicated. Day by day, experts, including medical experts, scientists, and pharmaceutical companies, are working to solve the issues. In the beginning of 2019, World Health Organization's new 5-year strategic plan can help the people at large. The focus is on triple billion target. One is ensuring 1 billion more people to benefit from access to universal health coverage. Next, 1 billion more people to be protected from health emergencies, and 1 billion more people to enjoy better health and well-being. Reaching these goals will require addressing the threats to health from a variety of angles. Air pollution and climate change, as I said earlier, is the worst enemy. Air pollution is significant global health risk, contributing millions of deaths and substantial disease burden worldwide. Air pollution, lead poisoning, and chemical pollution. Air pollution causes over 6.5 million deaths each year globally, and this number is increasing day by day. Lead and other chemicals are responsible for 1.8 million deaths each year globally, which is probably an undercounted figure. Pollution was responsible in 2019 for approximately 9 million premature deaths. Air pollution, both household and ambient air pollution, remains responsible for the greatest number of deaths, causing 6.7 million deaths in 2019. Water pollution was responsible for 1.4 million premature deaths. Lead was responsible for 9 lakhs premature deaths. Toxic occupational hazards, excluding workplace facilities due to safety hazards, were responsible for 8 lakh 70 deaths. The total effects of pollution on health would undoubtedly be larger if more comprehensive health data could be generated, especially if all pathways for chemicals in environment were identified and analyzed. Approximately 99% of the global population is exposed to air pollution that increases the risk of disease such as heart, chronic obstructive pulmonary disease, cancer, and pneumonia. Non-communicable disease such as diabetes, cancer, and heart disease are collectively responsible for over 70% of all deaths worldwide, or 41 million people. These include 15 million people dying prematurely aged between 30 and 69. That is very alarming. And if the appropriate actions are not taken to prevent this, the world will have the worst picture in near future. Air pollution was identified as the largest risk to health. It was responsible for 4.9 million deaths globally in 1 year and leading the risk factor for many health conditions, including respiratory infections and vascular disease. Now I am talking about South Asia. 33% of deaths due to pollution, according to the latest report on account of severe impact of pollution. More than 90% of pollution-related deaths occur in low-income and middle-income countries. So one will have to say that underdeveloped countries, if are not developed faster, they will invite more and more deaths and there will be more and more loss to the world at large. Air pollution accounted for 8% of the total disease, making leading contributor among risk factors. 34% premature births were attributed to pollution exposure. The rate of death, though has declined, yet on account of deaths caused by ambient particulate matters is 93%. During the period 2021, toxic chemical pollution lead is other serious pollutant. Pollution includes contamination of air by particulate matter PM 2.5, ozone, oxides of sulfur, and nitrogen. Freshwater pollution, contamination of ocean by mercury, nitrogen, phosphorus, plastic, and petroleum waste, and poisoning of the land by lead, mercury, pesticides, industrial chemicals, electronic waste, and radioactive waste. World has seen number of disease, and if that is not cured, there may be a serious problem. Just pardon me for a minute. We have seen Ebola outbreak in Congo, chikungunya virus disease, which is even today spread all over the world, Malaria, once upon a time that was eradicated, but again it has raised its head. COVID-19, world has seen the worst aspect. Yellow fever, Rift Valley fever, pig tapeworm and epilepsy. And the last, diabetes is the worst disease which is causing death slowly and gently. 90% of the population every day breathes polluted air. In 2019, air pollution is considered by WHO as the greatest environmental risk to health. Microscopic pollutants in the air can penetrate respiratory and circulatory systems, damaging the lungs, heart, and brain, killing 7 million people prematurely every year from disease, such as cancer, stroke, heart, and lung disease. Around 90% of these deaths are in low and middle income countries with high volume of emissions from industries, transport, agriculture, as well as dirty cook stoves and fuels in homes. The primary cause of air pollution, burning fossil fuel, is also a major contributor to climate change, which impacts people's health in different ways. Between 2030 and 2050, climate change is expected to cause 25 lakhs additional deaths per year from malnutrition, malaria, diarrhea, and heat stress. Apart from industries increasing traffic with no discipline, the police force is found not accountable, though they get salary from the public exchequer. The commissioner or the DSP looking after the traffic management are not able to get the traffic discipline. This causes a lot of pollution wherever there is a bottleneck or at the crossroads. Police never bother to bring the discipline in traffic. Many people are killed in road accidents. You will not find a rickshaw driver in uniform and with license badge. Why? Why they are permitted to take more than passengers than permissible, allowing the construction of high-rise buildings contrary to the regulations, and the regulations made are without application of mind. Town planning schemes is responsible for generation of pollution, as the use of number of cars and other vehicles in the streets are increasing every day, and the roads are not sufficiently wide, and many crossroads in the city add the problems. On many roads, footpath vendors are increasing daily, and at some places leaving one lane open, the entire road is occupied by them. These are the serious problems, and the citizens are the sufferers, and they are not able to raise their voice. Police have failed in controlling the traffic. It may be on account of inability to manage the traffic or other reasons which only police can provide. The problem are increasing the time of movement. Whom would you blame? The police or the people or the plan makers? 4.57 million vehicles were registered in the city of Ahmedabad in 2020, equating to nearly one vehicle for every two residents. Thereafter, there is increase every year. Two-wheelers are the largest, and three-wheelers are found more on roads than cars on account of frequency. All these vehicles are causing a lot of pollution, and the people who are residing nearby the roads or who are on foot, they are the worst sufferers. So far as the industrial pollution is concerned, that has caused a serious problem. It is also necessary to have industries at the same time as they provide employment, income to the public exchequer, and required output for the people or to earn the foreign exchange. But at the same time, the persons who are responsible, they must understand and see that the laws regarding pollution control are strictly complied with, and the officers must see that the same are strictly enforced. Let me tell you at the same juncture, while sitting in a green bench, I had an occasion to deal with many matters pertaining to pollution. There was an occasion to see all the industries in a town were closed because of water pollution. one very big industry in the city of Baroda was required to be closed, one part of the unit, on account of air pollution. Unless and until the strict actions are required, you will not be in a position to solve the problem. In this country and everywhere, by and large, people are interested in making easy money and to avoid or to provide necessary care and caution to see that there is no pollution that causes a lot of loss to the human life. They were not able to provide pollution treatment plant, and ultimately a system came which is known as common effluent treatment plant, where all industries together they met and they discharge their pollution to a common treatment plant. But there also some mischief mongers are creating problem and others are being harassed. And therefore, the important aspect is that who should be held responsible? The increasing number of hospitals meant for treating the patients are also responsible to some extent. However, some hospitals, by not following strict provision to eradicate the pollution, are creating serious problems. In Gujarat, there are about 60,632 industries and 48,950 hospitals. You will be surprised at why I am giving this figure, but you will now learn why. There are about 23,399 industries marked with red color, while 26,548 factories are marked with orange color and the rest with green color. One would be surprised to know that only 270 personnels are available in the technical wing on the pollution control board. How it is possible to enforce the law? If the people are law abiding, you do not require police. If the people are law abiding, possibly there may not be requirement of various agencies, but by and large, with a view to earn money easily, people are in habit of committing breaches of various laws, and the situation as there is today. Water bodies like rivers, lakes, and ponds are polluted by industries and others. People are aware about Holy Ganga and Yamuna getting polluted. The national capital in this season is found as most polluted city in the country. It is for the state government and the officers of the pollution boards to take action against the airing problems. If the appropriate actions are taken, people are the sufferer. The subject is very wide. However, I thought that the day-to-day problems be placed for the discussion. I thank you all, and particularly the university, for permitting to address the audience. Thank you very much. Once again, thanks a lot.
At the University for Social Law and Social Policy and for the German Agency for International Cooperation in Pretoria, South Africa. She holds 2 German law degrees and a doctorate in law from the University of Kassel. After completing her habilitation postdoctoral degree at the University of Regensburg, Dr. Claudia received the Pinia Legenda for German public law, public international and European law, social law, sociology of law, and comparative law. Before joining the European University Viadrina in 2020, she worked as an interim professor for public law with a focus on social law at the Goethe University in Frankfurt. Her research interests focus on questions at the interface between the law in the books and the legal reality. In this context, her published work includes studies on the influence of international social standards at a national level in South Africa, legal responses to social inequality under international, European, and German laws, and guaranteed socio-economic rights for asylum seekers and refugees in Germany. We are privileged to have you here with us today, ma'am. I hereby invite you to deliver the keynote address.
Thank you very much for having me this morning. I hope you can hear me properly. I'm very honored to be with you virtually. I would have loved to meet
Hello?
you all in person. I have had a look
Can
already
I,
at the.
will you permit me to go now?
I'm sorry, maybe. Yes, thank you. I had a look already at the various presentations that are going to be delivered today. It's such a vast variety of topics. I would have loved to join you in this regard. Allow me to also extend welcome from my university. We are happy to join you as a collaborating partner. The University of Viadrina in Frankfurt Oder, which you can see like in the back of my screen here, is based in Eastern Germany. And we are a very international university, and we would have loved to connect with you even further, and maybe we can also continue this collaboration. For today, I know that there are many practitioners in the room this morning. I'm a lawyer, and not only am I a lawyer, but I'm now talking about human rights, which is on a very abstract level. Maybe some sort of as a justification for the very abstract perspective this morning, allow me to say that I live with a family of doctors. My sister is a medical practitioner, my uncle, my aunt, my cousin. So there are a lot of doctors around me who I talk to on a daily basis, and we interact. And while I come from a legal perspective, and I would like to address this conference with, let's say, a broad abstract perspective this morning as some sort of aspiration that we need to work towards too. I'm going to share my screen, which is, I think, at this point not possible because I've prepared a presentation. I don't know, can you just now allow me to share my screen? If it's not possible, I'm gonna, all right. There we go, now it works. Great. I hope you can see the presentation now. Maybe you could signal me for just a moment if it's the case. Well, I trust that it's working, so I'm going to give you a quick overview of what I'm going to talk just now. The question that I want to ask is there a human right to mental health? That's the topic, and it's a very abstract topic. And I want to have a look at the United Nations framework and the WHO framework for answering this question. And I would like to share some key findings with you. As lawyers, quite often what we do is we analyze documents. We have a look at the legal texts in order to find out, is there a human right to mental health? So for those who want the short information just now, the short information is, yes, there is a human right to mental health, but it's complicated. So that was the summary of my talk. If you want to leave the room, please feel free to do so. If you don't want to leave the room, I'd be happy to explain the answer just now. Currently, I mean, these are figures from the WHO. We have over 1 billion people all over the globe living with some sort of mental disorders, mental health issues, and this number is on the rise. It has been intense specifically during the COVID-19 pandemic, but also the challenges of our current world are visible in these figures. As a lawyer, I would like to start with an international law perspective, and that brings me to the Universal Declaration of Human Rights. The Universal Declaration of Human Rights is in many cases a non-binding instrument which consists of certain principles and human rights. There are some binding human rights included as well. And the Article 1 states quite prominently that all human beings are born free and equal in dignity and rights. And if you asked me, why did you become a lawyer? Why did you become a professor? Why do you teach? That is the answer. That is what I believe in, that everyone is equal and everyone should have the same rights. The reality obviously is far, far different from that, and maybe you would also contest me on that view, but I'm being very transparent in my perspective, and that is the aspiration. And when we have a closer look, if we want to find out, is there a human right to mental health? The perspective is there a human right for mental health for everyone as well? From the international law perspective, you would first of all have a look at the United Nations, which is an intergovernmental organization. There are 193 member states. India was one of the founding members of the United Nations, of the early signatories of the United Nations Charter. The Universal Declaration of Human Rights, which was adopted in 1948, is a non-binding declaration, one could say a memorandum of understanding, which contains a variety of civil and political human rights, socioeconomic human rights. And the Universal Declaration of Human Rights was elaborated further in 9 core human rights treaties. For our discussions today, there are some human rights treaties which are specifically relevant. These are the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, specifically the Convention on the Rights of the Child and the Convention of the Rights of Persons with Disabilities. All of these instruments have been ratified by, well, I'm a German lawyer, so I've had a look at, did Germany ratified it, India has ratified also all of the aforementioned international law instruments. So this is a binding international law treaty, means that there are certain obligations to, well, to make those human rights in these instruments a reality, to achieve the progressive realization of these human rights. When we, as said, document analysis, so please bear with me because this is what I'm going to do now. I'm going to have a look at these instruments and when I want to find out, does it say anything about health at all? Does it say anything about mental health? Starting with the Universal Declaration of Human Rights for a moment just now, it states there is a right to a standard of living adequate for health and well-being. That is as a starting point. If we look at the International Covenant on Civil and Political Rights, there is more of a liberty perspective in terms of no one shall be subjected, for instance, to inhumane or degrading treatment. Everyone has the right to liberty. But with regard to socioeconomic rights, health rights, we don't find so much in terms of a positive right in the International Covenant on Civil and Political Rights. However, when it comes to medical treatment, the right to liberty and also the right to not be subjected to cruel, inhumane, and degrading treatment is of particular relevance. With regard to a right to health, there are more information. There is more information for me as a lawyer in the International Covenant on Economic, Social, and Cultural Rights. There is a right of everyone to an adequate standard of living, which is elaborated in Article 11. And most specifically, Article 12 of the International Covenant on Economic, Social, and Cultural Rights states that the parties to the covenant, so everyone who has ratified that covenant recognizes the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. So mental health is explicitly mentioned as a human right. So this is why I said the short answer to my question, is there a human right to mental health? It's yes. It's provided for in Article 12, paragraph 1. However, it gets more complicated if we have a closer look at what is actually meant by the highest attainable standard of physical health. Just to add, also, if we have a look at the other international treaties in this regard, looking at the Convention of the Rights of the Child, there is a right to health for children specifically, and there is specific mentioning of the enjoyment for mentally and physically disabled children of a full and decent life. And this is something which we will speak about in just a minute. There is a linkage, intersection between persons who are disabled from a psychological or mental perspective, and the question of, is there a human right to mental health? So not necessarily would one say that someone is a person with a disability because of certain mental health issues. However, you can also look at it from a human rights perspective. You can look at mental and psychological challenges from a disability perspective. So this is why we would also have a look at the Convention on the Rights of Persons with Disabilities, which clearly states that it does not only include persons with long-term physical impairments, but also mental, intellectual, sensory impairments. So there is a broad understanding of the term disability, and it's even broader because it includes not only the medical perspective on disability, but also the social perspective. So let's say the social model of health and the social model of disability is included, specifically when we look at the preamble, which states that disability results from the interaction between persons with the impairments and attitudinal and environmental barriers that hinder their full and effective participation in society on equal basis with others. So disability is not only about someone having certain challenges, but challenges that arise within the interaction with the environment, with people. This is included in the preamble of the Convention of for Rights of Persons with Disabilities. And there is also a right to health specifically mentioned in this instrument. So in short, with regard to the legal texts, we can say there is a human right to mental health. It is more concretized for children and for persons with disabilities, but in the International Covenant on Economic, Social, and Cultural Rights, we find a human right to mental health. For those who are not so familiar, I know that there are lawyers present, but there are colleagues from other disciplines present today as well. So super short lecture here on how does the supervision of international law actually work. So if a country ratifies an international treaty, this treaty is then binding in the country, and the country is obliged to implement the provisions in national law. There can be a distinction between a monist and dualist perspective. So for the experts in international law in the room, yes, but I'm just going to leave that out for a moment. Let's look at it this way. So we have that binding treaty, and it needs to be implemented in national law. There are certain supervisory elements, and the most important supervisory element, the regular supervision. Each state that has ratified that treaty needs to prepare a report with regard to the implementation of the treaty and send it to the committee which supervises that treaty. Usually it's done every couple of years, 2 years after ratification, 5 years after that, every 5 years, you need to send a report and need to report, well, is there progress? Where did you change legislation? What happened? There are also so-called shadow reports that can be prepared. So as a reporting procedure, and the committee will publish its concluding observations with regard to the implementation of that said treaty in a country. That's the regular supervision. There is, in certain cases, occasional supervision. That means that either NGOs or individuals can file an individual complaint with the treaty bodies, that is the committee which supervises the treaty. But that depends very much on whether the country, the state that has ratified the treaty, has accepted that procedure. So the occasional supervision also depends on the willingness of the state to allow that procedure. And as a third element of treaty supervision, the treaty bodies, the committees, they publish so-called general comments. The general comments are the interpretative guidelines for the treaty. So when Article 12 of the International Covenant on Economic, Social, and Cultural Rights states there is a human right to health, a human right to physical and mental health, that's super short. That is very broad and that's very open for interpretation. And the general comments help, or at least intended to help everyone who is applying the covenant in interpreting that norm. So I want you to keep in mind there is the supervision, and the treaty bodies publish their findings for every state every couple of years. That is part of the so-called jurisprudence of the treaty bodies with regard to the implementation of a specific covenant. And then there are the interpretative guidelines. So as I said, as lawyer, we have a look at texts. So the next thing I wanted to do is, if I want to find out, is there anything more about, to find out about the human right to mental health? Is there anything published in the general comments? What do the committees actually say? What is a human right to health, and what is a human right to mental health in those guidelines? And this is now listed chronologically in the guidelines for the Covenant on Economic, Social, and Cultural Rights. There is general comment number 5, which deals with the rights of persons with disabilities. Again, explains the term disability and includes a right to physical and mental health, also with regard to benefit from medical and social services. So there is at least certain mentioning of mental health in this comment. More prominently, for our purposes, is general comment number 14. So in the year 2000, the Committee on Economic, Social, and Cultural Rights published a general comment on the right to health. So this is where they actually elaborated what is the human right to health. And in this regard, first of all, they stated that the General Assembly, the United Nations General Assembly, did not adopt the broad WHO definition of health, which says that health is a state of complete physical, mental, and social well-being, not merely the absence of disease or infirmity. So they said, on the one side, okay, the General Assembly has not adopted that broad perspective of health. However, there is a reference to physical and mental health, and it's not confined to the right to health care. So it's broader, but not as broad as the WHO definition. It is also stated that the right to health is not understood as a right to be healthy. So maybe that is addressing the practical challenges on implementing a right to health. I mean, being healthy depends on so many aspects. And just because by law we say we have a right to be healthy, it doesn't enable us to actually provide for or make people healthy. That is something which is probably obvious in this regard. Further along the way, included in the general comment, there is a right to mental health care treatment. So again, the physical and the mental dimension are mentioned in the general comment. So this is the broad literature. What is most important in these guidelines is the AAQ approach. So the perspective on the human right to health, which is dealing with 4 categories. And I'm going to come to these 4 categories in just a moment. For those who even want more details, we have information on the right to mental health in the general comments on the Covenant on the Rights of the Child. So also with regard to the other instruments, we can find information on the right to health. And with regard specifically to the understanding of health, I just wanted to note that when it comes to children, so this is the Committee on the Rights of the Child, states that in the constitution of the WHO, states have agreed to regard health as a state of complete physical, mental, and social well-being. As we stated before, this positive understanding of health provides the public health foundation for the present general comment. And this is interesting because with regard to the Covenant on Economic, Social, and Cultural Rights, the committee that is responsible for that covenant said, well, the General Assembly did not adopt the broad WHO definition, and so we are not basing our definition on the WHO definition, whereas the Committee on the Rights of the Child adopts that broader view. This, I mean, this general comment was published also later than the previous one, 13 years later. So maybe there was also a change of heart. But that's part of the complication. So we have 2 committees supervising each one of the core human rights treaties, Convention on the Rights of the Child on the one side, economic, social, cultural rights on the other side. And one committee says this and the other committee says that. So there is some inconsistency. That is part of the complication. As a human rights lawyer, I would call for a more consistent approach in this regard here. What is important, and this is why I don't want to criticize the Committee on Economic, Social, and Cultural Rights too much here, because they provided a very, I think, for lawyers, helpful perspective in implementing the human right to health, and that also applies to mental health. It says that there are 4 key conditions that need to be in place when you, as a state, want to implement a human right, and with this regard, the human right to health. It needs to be available, it needs to be accessible, it needs to be acceptable, and it needs to adhere to certain quality standards. What does it mean with regard to the right to health? So availability, there need to be healthcare services, there need to be goods, facilities, they have to be there in sufficient quantity. And the realists in the room and the virtual room here, they would say to me, well, you can say that they have to be there, but we need funding, we need resources. And that is something which is, well, inherent to international law in this regard. It is an aspiration. It formulates something that states that ratify those instruments are supposed to strive towards to, with regard to their resources, with regard to the progressive nature of the realization of rights. But that is the plan. So obviously, if I say, well, they have to be there, it's a process and it depends on a lot of circumstances. I'm well aware of that. However, in this abstract perspective, the goods and services and facilities, they have to be accessible, not only physically accessible, but also economically, and for everyone without discrimination. Treatment, services, goods, they need to be acceptable. They need to be appropriate to all sorts of well, lifestyles and need to be sensitive with regard to the realities of the people that that make use of these facilities and goods and services. And obviously, there is well, aspiration with regard to the quality, the service, the goods, the facilities. They have to be of good quality. They have to be also obviously medically appropriate. So when I, as a lawyer, look at the human right to health, and if I want to look at a country and say, well, what is in place in that country? Does it actually implement a human right to health? The AAAQ approach helps me to break down the very broad wording of Article 12 in certain building blocks, and helps me to assess the reality of the implementation of that human right. So the AAAQ approach can, on the one side, support policymakers and state actors, but also non-state actors in implementing the human right, but it also supports those who supervise the human right to mental health and make sure that it's implemented in the countries that have ratified the covenant. Just that is also one tendency that lawyers have. They always have to be complete and precise, and they don't want to miss anything. However, I understand that I have a certain time frame, and I don't want to take up too much of the time this morning. With regard to mental health, still, the UN principles for the protection of persons with mental illness and the improvement of mental health care are one of the legal texts that specifically focus on mental health. So obviously, when we look at the human rights treaties, as I said before, mental health is mentioned, but not explicitly elaborated. More prominently and more elaborated, you find them in this General Assembly resolution. It's still, I mean, it's not up to date. It's from 1991. It's a non-binding instrument, so it's again a declaration of things that are considered to be important with regard to this, with regard to mental health. And some aspects are, I think, quite understandable in terms of when we talk about a mental illness. There is a principle of non-discrimination. There is a right to confidentiality, to not to be treated without informed consent, a right to privacy. Again, principles, something that is formulated as aspirations, something that we strive towards to, not necessarily something that is always a reality, but maybe something to use, a tool to use in the discourse in trying to make things better. There is a lot of criticism still with regard to this instrument. It's a non-binding instrument. And then one of the main critical points is that most of the principles refer to patients, which I think on the one side is understandable, but on the other side, it narrows the focus. It narrows the focus on patients and not on people. And the question is, so what if I'm not a patient? Do I also have these rights? So this is something which one could discuss in this regard. With the ratification of a human rights treaty comes the obligation to implement that treaty. As I said before, the regular supervision leads to the treaty bodies assessing the situation in a country every couple of years. There is a lot of jurisprudence, and I'm just gonna look at the one committee, the Committee on Economic, Social, and Cultural Rights. You can find the jurisprudence on the website of the committee. And I'm just going to give you a few examples here. What do they actually say when it comes to the human right to mental health? Germany, I'm not, because I usually the one in the room, the one person in the room shouldn't name herself first. However, I'm listing Germany here first because it's a chronological list, and Germany is currently under scrutiny in terms of Germany has prepared a report and sent it to the committee. There have been a lot of shadow reports in this regard because it's already at the moment there is a reporting cycle ongoing. And the committee has sent to Germany a list of issues, questions that they want to address. They want further information before they can formulate their concluding observations. So this is why I'm listing Germany here, because there has not been yet, they have not yet been formulated concluding observations. But Germany was asked, and it was asked to provide information in this regard on the availability, accessibility, and quality. So you see there is the AAAQ with one A missing in application here of mental health services. So Germany needs to provide information. So this is how the AAQ approach filters in the assessment process of the committee, specifically for asylum seekers and persons affected by trauma, but as you see, more as a broad element. And this is part of the process. The committee wants to know something, and then after the hearings, it assesses the situation. And there are some countries, I'm just going to list a few here, the United Kingdom, where the committee has expressed its concern about the high number of deaths by suicide and due to drug use and the rising levels of anxiety and depression. And there are certain recommendations that the committee formulates. For instance, with regard to Lithuania, the committee recommended to take measures, remove remaining forms of discrimination and stigmatization, and to ensure the overall levels of funding dedicated to mental health care services. And this is again part of the very soft way of implementing hard international law. It's a discursive process. The country prepares a report and tells the committee what has been done. The committee asks questions, and the committee provides its findings. Some who criticize international law say, well, it's just talking, it's not acting. But that is the element of supervising international law. It's by dialogue, it's diplomatic dialogue. This is the core nature of human rights supervision in this regard, with regard to the regular supervision. I've listed a bit more, but I am very aware that I'm close to the end of my talk. So if you want further information, I'm happy to share my slides. What I want to share just now, if we look at the WHO, the World Health Organization, as a UN specialized agency, obviously they are a prominent actor when it comes also with regard to mental health. They provide, and I'm sure the doctors in the room, the medical practitioners in the room are aware of the ICD classification system and the ICF, which are a way of, well, categorizing our health issues, also mental health issues, with all the benefits, but also the challenges that come with the categorization. And specifically, due to the complex nature of mental health issues, the classification system provides its own problems in this regard. I wanted to share with you that there is an action plan specifically with regard to comprehensive mental health, which has been formulated by the WHO, and they are also trying to implement the human right to health within the framework of this action plan. For this morning, what are the key findings or the key messages that I want to give with you for the conference? First of all, freedoms and entitlements need to be distinguished. On the one side, the freedom perspective prohibits treatment without consent. whereas the entitlement treatment, the entitlement perspective calls for the AAAQ approach, calls for services to be in place, treatment to be in place of good quality, needs to be available and accessible. The human right to health, but also to mental health, is protected under international law, and there is a network of different rights at the interface of the human right to mental health. There is an intersection of mental health and disability. It makes it complex, and also with regard to the terminology, it's not always consistent, and this is one of the further challenges when it comes to the implementation of the human right to mental health. We can identify in some instruments, they rather follow the biological or biomedical model of health, which focuses on impairment, to put it this way. And some instruments focus rather on a social or a biopsychosocial model of health, which is probably more useful in this regard, also with regard to the different dimensions of challenges that we focus when it comes to mental health. Obviously, the AAAQ approach is not only focusing on physical health, but it focuses on mental health as well. And non-discrimination, we find it as a cross-cutting issue in all the human rights instruments. Obviously, the human rights are to be implemented progressively within the available resources. So it allows for a margin of appreciation with regard to the implementation. And this makes it so difficult because states have certain challenges when it comes to resources. And the question is, when is it justifiable and when is it necessary to say, well, now you could have done more, you should have done more. And to come to the end of my talk this morning, as you have seen, I mean, first of all, because I have talked a lot, but because there are a lot of legal texts, lawyers work with language. Human rights are a discursive tool. We need to talk about human rights. We need to talk about a human right to mental health. And when we talk about it, we implement it in interacting with others in terms of if we are working in which field ever, which is linked to mental health, we can hold states accountable. We can hold states accountable for not implementing the human right to mental health in a way that is compliant with the International Covenant on Economic and Social Rights. However, human rights are a practical tool. It takes human action to make them a reality. I can say a lot of things this morning which should be done, but they won't be done unless someone does them. And it's maybe easy for me to sitting in my academic ivory tower to say, well, it should be done this and this, but there needs to be an interaction between like, for instance, me as a lawyer to say, well, it should be this way, it should be that way. And everyone who is working to make human rights a reality. So thank you very much. And I wish you good luck for the conference today. And I'm happy to answer questions if there are any. Thank you.
Ma'am, thank you for such an insightful session. We are very, very grateful to have you in the international conference and for your collaboration. Ma'am, but sorry, due to some time constraint, we need to start the technical session. So can you just mail your PPT, and then what student will do is they will forward you the questions and then we can connect accordingly.
All right, of course. Thank you very much.
Okay, ma'am. Thank you so much for the session.
Dr. Claudia Maria Hoffman for sharing her valuable insights and technical expertise with us. Your thoughtful perspectives have truly enriched our understanding and have added great depth to today's discussion. Thank you, ma'am. Also joining us today is Dr. Sandeep Sharma, member of the Indian Council of Medical Research Committee of Standard Treatment Workflows and consultant plastic cosmetic surgery. Sir is the founder and director of Aesthetic, a plastic and cosmetic surgery center in Vadodara. Sir was the president of the Indian Association of Aesthetic Plastic Surgeons from 2021 to 2022 and the APSI Traveling Professor in Cosmetic Surgery in India in 2024. Sir is the chairman of the International Outreach Committee, IAAPS Global, former consultant plastic surgeon at the Royal Dental Hospital, Australia, and former assistant professor in plastic surgery at the Government Medical College, Vadodara. Sir has been a part of various national as well as international conferences on plastic and cosmetic surgery as a speaker. Sir was the co-chair of the German National Conference in 2023 in Berlin and recently delivered the presidential address at the National Conference of the British Association of Aesthetic Plastic Surgeons held in London on the 2nd and 3rd of October 2025. We are pleased to have you with us today, sir. I hereby invite you to please share a few words with us.
Very good morning to one all. Even phone call. My fellow Justice BC Patel, Professor Hoffman, Guten Morgen, and also the faculty here, Professor Sujata, and Maria. Thank you very much for inviting me to this conference here. Well, I'm a plastic surgeon, and in society, I deal with both wellness and illness. Illness because I look after injuries, both the face and hand, to burn injuries, to reconstruction after cancer, and wellness also after free quality of skin, hair, including body form as part of that. So, and there the society both in the good times and the bad times. So, give me a very different perspective to what affects people in our society. So, today's topic is very relevant when we talk about law, ethics, and policy. And the health of a nation, I feel, depends not only on the doctors and hospitals, but also on the policies of law and ethics. So, when we look at law, we all have, we can look at patient-centric laws, which affecting, you budding lawyers in terms of, litigation and the CPA or the Consumer Protection Act. That's sort of what is the interface between lawyers and doctors. It's in common, and that's important to know what you guys be taught about. Or we're looking at the society in general, where we're looking at, how we can influence laws, which is PILs. And I think PIL, public interest litigation, is very important. And I hope that more and more people are able to use this very important weapon in your armamentarium to help improve healthcare in our society. So when we come to talk about that, that's laws. When we talk about ethics, ethics is not only when we talk about healthcare, people think comes up as which relates to doctors. No, ethics governs all the stakeholders in health, which is the government, number one. So we cannot presume the government of the land to be ethical, and it is on us to push to make sure that they stay ethical. Same thing is with doctors. Doctors have to be ethical. There's a code of ethics, and that also borders with morality. But then very important also to see is the ethics of society itself. We've got to understand that a society which doesn't have good ethics is going to be reflected in the ethics of the doctors as well, because ultimately doctors are products of the same society. So the key is basically to improve overall ethics in our society. So ethics and morality go hand in hand. So as the Gen Z and the young generation, I feel that this is very important that you take on board as you educate yourself, as you train yourself, to look at the bigger picture to make sure that we are a much more happier and a much better society where healthcare does deliver what is missing. Coming to policy, again, I think personally that the lawyers outside of governance are the biggest or the most influential who can influence and change and modulate health policy. So there is a significant onus on the current lawyers as well as you lawyers of the future to see the bigger picture and not just the laws which are already in place, to make sure that we have better laws, better policies so that healthcare can improve, because there's still a lot that can be done to improve healthcare. As Dr. Sujata had talked about, when there's new cutting edge technology coming in, there's AI, there's robotics, there's stem cell research and new research. So how does, the laws of the land, how the policies affect that? And that, as young budding lawyers, you should be on top of it. So that will be taught and that will be done. But to me, I'll just raise 3 points which are having a big impact on the current state of healthcare in our society. And obviously, whenever things have to be improved, there has to be a legal angle to it. So you people have to be aware of it. The first thing I'll talk about is about a very burning topic is violence against doctors. So when you talk about violence against doctors, the immediate thought comes to mind is that there must be some omission or commission which led to this. But then often there is more than what meets the eye. You've got to understand that healthcare in India, as envisaged, is that the government system is responsible for affordable healthcare, and the private sector is responsible for quality healthcare, and that's how society progresses. But what's happened is that over the years, the government has been abdicating its responsibility. So it is not taking care of the affordability, providing healthcare to all. And we all know that it's a fundamental right enshrined in the Constitution of healthcare to all. And that's Article 21, which says right to life. So that translates as per the Supreme Court judgments into right to healthcare. So that makes it a fundamental right. And the government of the land is abdicating on that. It is coming up with policy changes and yojanas, which is actually washing their hands off, passing it on to the private sector. So we have a doctor here who is caught, like we use the phrase of cricket, that he can't play on the front foot to give quality care, he can't play on the back foot to give affordable care, and that's why he's caught out. And so he is the actual meat in the pie, and is the brunt of violence. So as lawyers, you've got to see how we can influence policy that such ridiculous situations do not dictate our society. Recently in Madhya Pradesh, similarly, there was this thing about the unfortunate instance of many babies dying because of spurious cough syrups. And you know what happened? It was the doctor who was indicted and was acted on once, was violence created, and none of the licensing authority, the administration, the pharmaceuticals. So that shows a very, very skewed sense of justice or a skewed sense of problem solving in our society. So we may talk about higher things in terms of the newer advances, but still at the grassroots, at the middle level, there's still a lot of things which need to be set right. And so for violence against doctors, when you talk about law, there is law, but that has not been uniformly implemented across all states that prevent violence. So the ethics of it affects the doctor because he doesn't know whether he should look after the patient or defend himself, both of which are important. So there's an ethical dilemma there, which has to be solved by society and the law, not by the stakeholders. And so we need to have policies which actually take care of this issue. And this is not going to be guided just by litigation. The other issue which I talk about is quackery. Quackery is basically someone who dishonestly promises to have a skill or a qualification which he actually does not have. So this is actually working against the law in two forms. One is malfeasance, which is basically not delivering the service which is promised, or actually basically means doing no harm, they're actually harming the patient because they're not qualified. And also it is a travesty of justice because the qualified doctors are being dealt an unfair hand, that they have to compete with people who are actually not qualified. So these things impact both ethics as well as have to be taken care in policy that these things are properly addressed. The third point I would like to talk about is social media. Social media, again, is very much evolving. The laws of the land are not keeping pace with that. So we have to, as both lawyers and doctors, see how we can sort of help that getting implemented into policy. Because ethically, it is affecting and demoralizing the doctors that practice, because they have to decide whether they have to be involved in social media or they have to be involved in providing service. So this is a wastage of time and wastage of talent. So these things need to be addressed. Now, I will take you through three scenarios. You people are all aware of this ad campaign to see on TV, which is that the Maku Masala ad where the Zuban tastes you. One side. Which one? I hope you are aware of that. No, those. Yeah, correct. That one. So there we have these film stars, promoting ill health. And then we have a seminar here on healthcare. Isn't it obviously that should not be there? Shouldn't we, as a group of doctors and lawyers, go after these people, including politicians or whoever? Why should there not be a ground movement that this should be done? Right? So it is an open and shut case, but our society is blind. Right? Which is not fair, because we all know you have this tobacco, you're going to have cancer. Right? You're going to have cancer, you're going to be a burden on society. You're going to be a burden on your family. Right? So it is a lose-lose situation. These people, they throw the paddies all around. So it's hygiene issue, right? They spit tobacco everywhere. Again, a hygiene issue. Who's putting the bill for all this? Us, the country, the nations, the citizens. And then we have a shortfall on budgets. So I think these things have to be addressed. And who can do that? I think that is only the law which can do that, or the lawyers, the young lawyers who can do that. So it is actually a lot of burden on your shoulders that these things have to be taken up, because if they are not to be done, we as a society are going to suffer. So no point in fixing small problems when the bigger problems are not being addressed properly, right? So that was one thing. The second thing which affects all of us over here is food adulteration. We all work hard, earn an income so that we can have a good living. A good living means healthy living, and that's what healthcare is all about. But if you got so much of adulteration, so the obvious open adulteration, that there is not enough law, or in fact, there's so many laws, but it's poor implementation of law, there's poor failure of governance, that we have so much of food adulteration, which is the key to all the illnesses that we have. Why does India have the maximum number of deaths in cardiac deaths, cancer deaths? It's all because of food adulteration. So if you want to do healthcare, these things can only be tackled legally. So there's a lot of scope for law, there's a lot of need for law, there's a lot of need for good lawyers. So, your profession, if tackled properly, is going to be very well employed for your lifetime. So you really need to sort of choose your battles, and they're big battles to be fought. And lastly, I talk about wellness. Wellness is important, and in the healthcare policy, I think there is not enough emphasis on wellness. You have to be fit. You have to fight obesity, you have to fight diabetes. I'll give you the example of Japan. In Japan, there's legislation that every school has to have a nutritionist who is not only a teacher, but is also qualified for nutrition. So you have to do your BA degree and then followed by a nutrition degree. And that nutritionist decides the diet of the school. So from the age of 6 to the age of 16, everybody eats in school and they only get healthy diet. Everything has been freshly cooked. So in the formative years, they are only used to healthy diet. And believe me, after age of 16, habits not change, food habits not change. So you have a healthy society. So you have a full country where there is zero obesity. And they are the richest country in the world, or the top 3 in the world. And here we are, so poor, but still we've got so much of obesity. Right? So it is absence of policy, which leads to absence of determination, which is causing these problems. So with these, I will not take your, I hope I've got some new thoughts into you youngsters, but I would conclude by saying that I would urge you to engage in drafting better legal protections for the topics I've mentioned and many more. Advocating ethical governance, which is sadly missing. And it is only people with a higher IQ, with a higher, good family background, with good academic teaching, who can think about academics and morality in life. And finally, shaping the tech age new policy which come up, because only you guys actually know all these new technology. Thank you very much.
Thank you so much, sir, for sharing your profound insights on the intersection of health, law, and morality. You have greatly enriched understanding and inspired meaningful understanding among the students. We would like to thank all the dignitaries once again for being a part of this event, and we are deeply grateful for your presence. We would like to thank Honorable Justice B.C. Patel, sir, and Dr. Claudia Hoffman for joining us virtually. Your presence has added a significant to this event. We would like to present a small token of our gratitude to all the dignitaries present here today. I invite Dr. Sujata Patil ma'am to extend a token of gratitude to Dr. Shah. I would like to invite Dr. Sujata Patil ma'am once again to extend a token of gratitude to Dr. Medhavi. I would now like to invite Midula Thomre ma'am to extend a token of gratitude to Dr. Yuvraj Singh Lal. Now, I would like to invite Ms. Nidhi Jain ma'am, Assistant Professor, School of Business and Law, to propose the formal vote of thanks.
Thank you is such a prayer that can only be felt by heart. I feel honored and privileged to get this opportunity to propose a formal vote of thanks on this special occasion. A very good morning to all the dignitaries and the audience. I, Nidhi Jain, on behalf of the organizing committee, extend heartfelt gratitude to all the dignitaries who grace this occasion with their presence. Thank you for sharing with us your findings and opinions today. I feel truly honored to welcome Justice Honorable B.C. Patel, former Chief Justice of Jammu and Kashmir and Delhi High Court, and member of National Human Rights Commission, who, despite an unfortunate incident, graciously joined us online today. We are deeply grateful for his commitment and time he devoted to addressing us. His profound experience has undoubtedly added to the knowledge of the participants today. I would also like to thank our keynote speaker, Professor Dr. Claudia Maria Hoffman, Chair of Public Law and European Social Law, European University Weizsäcker, Frankfurt, Germany, for her engaging and insightful address. Ma'am, your expertise has provided us with a deeper understanding and will undoubtedly inspire meaningful discussions among the participants. Heartfelt thanks to our distinguished guest, Dr. Sandeep Sharma, member of ICMR Committee of Standard Treatment Workflows and consultant plastic and cosmetic surgeon, for his valuable presence. Your insights have added depth and relevance to today's discussion, sir. I extend my sincere thanks to each one of you for accepting our invitation and contributing your expertise to this significant time. Your presence is a testament to the importance of this international conference. I extend my deep gratitude to our collaborating partner, the European University of Frankfurt, Germany, for joining hands with the School of Business and Law, Navrachana University, in organizing this event. Your collaboration added immense value and a global perspective to this academic endeavor. I also express my sincere thanks to Zydus Hospital for their collaboration and continued support, and to our sponsor, IMS, whose contribution has been instrumental in ensuring the success of this event. I sincerely thank our respected provost, Professor Pratyush Shankar, and Registrar Dr. Sandeep Vasan for encouraging us and supporting the success of this event. I am grateful to our dean, Dr. Hitesh Bhatia, and Principal Ma'am, Dr. Sujata Patil, for inspiring mentorship and constant guidance at every step. Thank you, sir and ma'am, for trusting us and giving us the opportunity to organize this grand event with all the necessary support. This wouldn't have been possible without your ever-ready solutions to every challenge. Thank you to all the participants for your active involvement and willingness to attend the conference. I would also like to thank all my colleagues who really work hand in hand to make this event successful. Thanks to the administrative staff for the technical and logistical support that they have extended for us for this event. Last but not the least, thank you to all the student volunteers who have put an immense effort to organize this event happen. In such a short time, you have made the best possible arrangements for this program. Thank you wholeheartedly. I hope we continue to work together and organize such event in near future for the betterment and upliftment of our students. Thank you.
We would like to announce the formal culmination of the inaugural session. We will now begin with the technical sessions of I would like to request all the volunteers to come up to the stage for a photo with the dignitaries. I would like to invite all the faculties as well.
Yes, Claudia ma'am. Yes, ma'am, we are done with the inaugural session. Now we are going to start the technical sessions. So thank you so much for your insightful session. You may leave the meeting now.
All right. Thank you so much.
Thank you for your session, ma'am. Thank you.
Thank you.
हम लोग